Facebook. Not Facebook, sorry. On YouTube. So if you missed a class or you just want to recap, go over the classes, the work again, the recordings are there. Easier to access them via YouTube than it is to have to download from Teams. Okay, just give me a second. I just want to share my screen. Okay, so just while I'm busy sharing my screen, just to recap what we've done so far, we've finished with the law of purchase and sale. The fact that we finish, sorry, I'm not thinking tonight. We finished with the general principles of the law of contract. The fact that we have finished with the law of contract does not mean you can tick that off and forget about what you learned there. We are now, for the rest of the semester, looking at specific contracts. And the principles that you learned, the basic law of contract, all apply to specific contracts. You can't separate those units from the units that we are doing, the forthcoming units. You have to see everything as a whole. Okay, thumbs up quickly if you can see my screen. Thank you, Mr. Bester, Mr. Lisser. Okay, so we've learned so far that a contract of purchase and sale is a reciprocal agreement for the delivery of a thing, for the transfer of possession of a thing in exchange for a purchase price. In order for a contract to be a valid contract of purchase and sale, firstly, the contract must be valid. Then there must be the agreement to buy and sell. There must be an agreement on the thing and an agreement on the purchase price. Once you have this, you have purchase and sale. If you have a contract of purchase and sale, because it is a contract of purchase and sale, there are certain implied terms, that will always apply because it's purchase and sale. Doesn't matter whether you're buying a loaf of bread or whether you're buying a house for $3 million or a car for 300,000. These provisions will always apply because it is purchase and sale. If you don't want them to apply, you have to expressly exclude them. Some of these implied terms are the duties of the seller. We looked at the first duty of the seller, namely the duty to deliver the thing. Delivery, that doesn't mean taking it to the premises of the purchaser. In terms of the law of purchase and sale, delivery means to make the thing available so that the purchaser can take free possession of it. Closely connected to the duty to deliver is the duty to guarantee against eviction. Going back, reiterating again, contract of purchase and sale is a contract for to transfer possession, not a contract to transfer ownership. Ownership, in fact, is an incidentalia. It is an incidental result. It is not a natural legal consequence. We've already seen that the seller does not be the owner. And obviously, if the seller is not the owner, the purchaser cannot become the owner, because you can only transfer as much rights as you have yourself. Just to clarify that, if Stacy lends me her cell phone, she gives me her cell phone to use for a week, I will then have possession of the cell phone. And possession, the fact that I'm in possession, gives me certain rights. But ownership is a more complete right, a more extensive right than mere possession, merely holding something. If Stacey is lending me her cell phone, I have possession, but I do not have the right of ownership. And because I do not have the right of ownership, I cannot transfer ownership to anybody else. So you can only transfer as much rights, as many rights as you have yourself. But obviously, and I can almost see you becoming confused. Just a reminder, I've told you before, think with your heads, don't think with your hearts. But I'm sure you're saying at the moment, you're sitting there listening to me thinking, but then why am I buying something if I'm not going to become the owner? I buy it because I want to become an owner. And yes, I totally agree. That is why you enter into a contract of purchase and sale. But as I said, ownership does not automatically pass with delivery. So the fact that you have taken possession of the thing doesn't automatically make you the owner. Then when will you become the owner? You will become the owner if so what are the requirements? Of ownership? Firstly, in order to transfer ownership, it must be the intention of the parties. Now you might ask, but isn't it always the intention of the parties? In most instances, it will be, but it isn't always. If you buy a car, for example, and you finance it through the bank, that car actually belongs to the bank. Although you have possession of the car belongs to the bank, and you only become the owner once you have paid the last installment. So ownership will only pass if it is the intention of the parties. And secondly, if if the seller is the true owner. If the seller is not the true owner, you can have intention until you blue in the face, but ownership will not pass. Now, what happens? Now, because now I can see you starting to think, but so now I have entered into a contract of purchase and sale. I did not know that the seller is not the true owner. Now I've paid for it and I cannot become the true owner. What happens to me now? In the instances where the seller is not the true owner, the purchaser is protected by the seller's duty to guarantee against eviction. It's referred to in the study guide as the tacit guarantee against eviction. Tacit guarantee, silent, it's implied. When you buy something, there's no need to expressly ask the seller, are you the owner and do you guarantee that nobody will come and take it away from me? Purely because it is purchase and sale, this guarantee exists in every single contract of purchase and sale, unless the parties have expressly agreed to exclude it. It automatically forms part of a contract of purchase and sale. What does this guarantee against eviction mean? It means that the seller undertakes to give the purchaser undisturbed possession of the thing. Another way to say the same words, it guarantees that nobody with a better right will take the thing away. The purchaser will not be evicted. Just be careful, the word eviction in this context. We all know the word eviction. That's if you're living in a place and you haven't paid your rent and the landlord tells you to pack your stuff and leave, you're being evicted. Eviction in this instance has a wider meaning than just being kicked out of premises. Eviction means the thing that you bought, that was handed over to you, that you took possession of, is taken away from you. Now, in terms of the guarantee against eviction, the seller undertakes to give the purchaser free, undisturbed possession of the thing, guarantees that nobody with a better right will come and take it away. So, although the contract of purchase and sale does not guarantee the transfer of ownership, it does guarantee that you will remain in possession of the thing that you bought. In order to be able to rely on this guarantee, however, the purchaser has certain duties. Need to know these duties. So the purchaser must act in a certain manner in order to rely on these to rely on this tacit guarantee against eviction. Firstly, the purchaser must try to keep the thing in his possession. So if you've bought something and somebody else comes and says, no, that's mine, give it to me, you can't just say, oh, okay, there it is, take it. You have to, by all means possible, try to keep this thing and only hand it over if there is indisputable proof that it does in fact belong to the third party. So if the police come or if there's a court order and say, hand over the thing, we're not expecting of you to defy the law, get yourself arrested because you're frantically holding on to this thing. But you need indisputable proof before you hand it over. So try to keep the thing in his possession, notify the seller so that the seller can come to your assistance. Let the seller know what is happening and defend your position with all means. So insist on a court order, etc., etc. Conduct a strong defense. Although this is, I said this is a tacit guarantee against eviction that applies to all contracts of purchase and sale, there are certain instances where the purchaser is not protected. Instances where the purchaser is not protected is firstly, if the parties agree to exclude the guarantee. Remember what I said when I started today? That these are natural legal consequences. They will always apply unless the parties expressly agree to exclude them. So obviously, if you have agreed to exclude them, you cannot, or exclude this guarantee, you cannot subsequently want to rely on it. You can use common sense. I'm pretty sure you all agree that although you can agree with the seller to exclude the guarantee against eviction, that would be a rather stupid thing to do. If you come to me, let's see, Miss Kluter comes to me, I offer to sell her my cell phone, and she agrees to buy it for $1,000. But then I say to her, but listen, part of our contract is I cannot guarantee you that it doesn't belong to somebody else and somebody else might not come and claim it from you. She would be stupid to agree to that. Okay, I'm going to pay you $1,000, but I don't know whether I'm going to be able to keep this because maybe it belongs to somebody else. Then she's not going to buy it for me for $1,000. So this guarantee, although theoretically it can be excluded, in practice, it would not make sense to actually exclude this guarantee. But if it has been excluded, obviously, then the purchaser will not be protected. Also, if the purchaser is aware or should reasonably be aware that the seller is not the owner, then obviously that's the general concept of you cannot go to court, you cannot approach the court with dirty hands. If you know you are buying stolen goods, the law is not going to protect you. If I'm in the parking lot at Vernhill and some scaly looking man comes to me and opens his coat and shows me an iPhone and says $500 and I buy it, it's fairly obvious that this is stolen property. So if somebody, the police subsequently tracks it down and takes it away from me, I cannot try to claim that, oh, guarantee against eviction. And also, the seller is not liable if the eviction is not the fault of the seller. So land expropriation cases, for example, if you have bought land from somebody and the government subsequently comes and says, no, we're taking that land away from you because we need it for a railroad or whatever, it's not the fault of the seller. You can't hold the seller liable. But if it's not one of these instances, so it's not one of the instances where it doesn't apply, and the purchaser has followed the rules, but despite that, the thing is evicted, it belonged to somebody else, and they could prove it, and you are deprived of this thing, the true owner took it away. What is the legal situation? How does this affect the contract? Somebody, quickly. So the seller has the duty to guarantee that nobody will take it away. Now somebody comes and takes it away. What effect does this have on the contract? Come on, quick, 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 quick. Why is there silence? Ms. Kamati, Ms. Simata. Ms. Simata, from which Ms. Simatas are you? Are you related to George Simata? Come, I don't believe this. Wakey, wakey. What effect does it have? The seller has a duty in terms of the contract. Now he doesn't do what he's supposed to do. He doesn't fulfill the duty. What do we call this in contractual terms?
Is that not the cancellation, ma'am?
No, why would it be cancellation? Nobody's cancelled the contract.
Breach of contract?
Breach of contract. Breach of contract. I'll be honest, the moment the contract is cancelled, there is no contract and you have no rights, you have no protection. The seller has a duty. He doesn't do what he's supposed to do. It is breach of contract. The contract doesn't suddenly fall away or become void or whatever. It is breach of contract, people. Units 2 to 8. No, 2 to 7. Contracts, law of contracts. I started off this lecture by telling you, don't forget what I taught you there. So it is breach of contract. And because it is breach of contract, your normal contractual remedies will apply. Go back and revise Let me check what unit that is. 7 or 7, 6. People, I'm going to assume that you know and understand the work from units 2 to 7. I'm not going to be teaching you things that I taught you a week or 2 ago. Make sure that you are not getting left behind. Okay, questions about that? Let's move on then to the next duty. So duties we've had so far is the duty to deliver. I actually want to just copy them because right at the end of the unit, I want to be able to give you a list of all the duties of the purchaser, of the seller. In your first test, another question I'm going to ask you in the test is to list the duties of the seller. Always remember, if I'm asking you to list something, always read your questions carefully. If I'm asking you to list something, you don't have to discuss them. A list is just that. It is a list. If I want detail, I will ask you to discuss them. But I will never ask you to discuss all the duties. Then I will indicate which duty I want you to discuss. So the next duty then is the duty to keep the thing in safe custody. This duty, and first of all, this is one where in my many years of teaching this work, unfortunately, I can literally see the lights going off in the class. Think with your heads, not with your hearts. Firstly, this duty only applies if delivery does not take place at the same time as contracting. If you buy a loaf of bread and you walk out of the shop with this loaf of bread in a plastic bag, or you buy my cell phone and you pay me there and then, and I hand the cell phone to you. So delivery is at the same time as contracting. This duty is not relevant. I can't say it doesn't apply because it applies to all contracts of purchase and sale, but it will not be relevant. It's only relevant if there is a period of time. So we agree today that Stacy will buy my cell phone. So the date of the contract is today, but we agree that she will pay me and take delivery of the cell phone at the end of the month. So between now and the end of the month, there is a period of time. Between now and delivery, I have the duty to keep the thing in safe custody. So if she buys it today and we agree she will pay me and take delivery at the end of the month, between now and the end of the month, I must look after this phone. I must make sure it doesn't get damaged. I must make sure it doesn't get lost. If I don't do this duty, it's damaged or lost due to the seller not keeping it safe. This is breach of contract. I had the duty to keep it safe. I didn't keep it safe. I didn't fulfill my obligation. It is breach of contract. But now there's another aspect of the law known as the passing of the risk rule. The passing of the risk rule, and this is important. Passing of the risk rule is also known as the risk doctrine. The passing of the risk rule states as follows, that if the thing is damaged, not because the seller did not keep it in safe custody, but due to accidental damage, if there is accidental damage, the risk will pass to the purchaser. The contract is perfecta. Passing of the risk rule applies only to accidental damage. If the thing was damaged due to the seller not keeping it safe, keeping it safe, the seller is in breach of contract. But if something happens to the thing that is not in the control of either of the seller and the thing gets damaged, then the purchaser, the risk will pass to the purchaser, and the purchaser bears the loss. When does the risk pass? When the contract is perfecta. Another word for perfecta is complete. Please note, perfecta, it is a legal term. It's not the same as perfect. Don't say when the contract is perfect. The word perfecta confuses you. Say when the contract is complete. So when is a contract perfecta? Contract will be perfecta when the price is fixed, when the thing has been specified, and when it is unconditional, if there are no suspensive conditions. What is a suspensive condition? Go back and do revision. It's discussed both in Unit 7 and Unit 8. So if those three conditions those three requirements have been met, the price has been fixed, the thing has been specified, and there are no suspensive conditions, the contract is regarded as being perfecta, regarded as being complete. The risk passes to the purchaser, and if the thing is damaged or lost, the purchaser is still liable for the full purchase price. And this is where the lights go off, where everybody turns around and says, but miss, I don't understand this. I don't understand passing of the risk rule. Because you're thinking with your hearts. You're thinking, but now the thing is damaged and I must still pay. Hedwig, your hand is up.
Yes, Miss, I would like to ask something about the risk, passing of risk.
Yes, go ahead.
Let me say, for instance, maybe I paid for product from a certain market, and I paid in advice, like they were maybe not in the market at the moment, so I paid in advice.
Sorry, Hedwig.
Yes.
Can you start over? You were a bit fast. I couldn't follow what you were saying. Ask your question again, please.
I would like to know now about the passing of the risk. Now, in case now, maybe I order product from a certain market, and by the time I order, the product were not available, and I paid in advice, and I paid also with the transport, like the seller must provide everything once it's available. In case now, if any of the product get damaged through the process of delivering the product, will that risk be passed to me?
Hedwig, this is where students, and thank you for asking the question, because this is where students start saying, I don't understand this. In terms of the passing of the risk rule, in terms of the strict application of the passing of the risk rule, if those products get damaged while they're being transported to Namibia, you get the broken stuff and you still have to pay the full price. Now you're going to say, but how? Whoa. Now to say, what if I paid? If
I paid,
that is,
right.
if you pay, it doesn't matter whether you've paid or you haven't paid. If those things get damaged, in terms of the passing of the risk rule, you have to pay the full purchase price. Now you're saying, but that doesn't make sense. Why must I pay? This is where I'm coming in and I'm saying to you, think with your head, don't think with your heart. In terms of the passing of the risk rule, this is how it works. But this is an implied term. Let me just get that. I've said that in the beginning. Will always imply unless the parties expressly exclude them. This is how the law works. You will still be liable, but it can be excluded. You can agree with the shop that this will not apply. And I can promise you, any reputable dealer, Home Corp, whatever, Incredible Connection, etc., etc., although by law they can insist on you having to pay the full price for the damaged things, they won't. Because if they insist, okay, well, the computer is smashed, but we want all our money, they can legally do that. But you're going to be telling Ryan and Celine and Roland and Stacy and Elvianus and Sebastian, and nobody is ever going to go back to that shop. It's not good customer service. So don't confuse the strict legal principle, which I'm teaching you and that I'm going to be asking you questions about in the test, with the practice that happens in trade. Do you understand what I'm saying?
Yes, I understand.
Yeah. So legally, they can insist that you have to pay or keep your money if you've already paid. In practice, they won't do that. They'll refund you. Don't confuse the strict legal principle that I've just taught you. Think with your head, not with your heart. But
Sorry,
in
ma'am.
practice, yes, Sharon.
So it means it's just a rule, but still the seller can still how should I put it? Can still refund the money if they have to, whereby it says will always apply.
Whoa, Sharon,
Okay.
not if they have to. They don't have to. If they want to. If
Okay.
they want to. But in practice, from a shopkeeper's sense, good marketing, etc., they will give you your money back. But you can't say they have to give you it back, because legally they don't have to. But I can promise you they will want to, because they want to keep their customers.
Oh, okay. No, I understand now.
Okay. Martha, your hand is up.
Yes, no, I wanted just to make it how I understand, to explain to the colleague that not every, like to say they can do it if they have a heart of doing it, but by law, I think we should look at things by law, what the law is saying. Whether they do it or they don't do it, what is matter is what is the law saying about this incident.
The law says, by law, they can make you pay the full amount. Legally, they have the right to keep all your money. Legally, they don't have to refund you. But from a practical point of view, it won't be good business, because they will lose their customers. So they will want to refund you. But by law, they don't have to. Think with your heads, not with your hearts. So let's just get back to what I was saying here. These requirements for the contract to be perfecta: the price must be fixed, the thing must be specified, and there must be no suspensive conditions. Contract must be unconditional. Just make sure there's a little bit of more detail about these requirements in the notes. Just make sure that you do refer back to the notes. Not going to type everything out here. So refer to page 47. There's just some explanation about when is the price considered as fixed, when does is the thing sold considered as specified? And suspensive conditions, we have discussed those previously. Okay, let me just get my thoughts together here. I think that's about what I wanted to say about the passing of the risk rule. Price is fixed. If the thing is damaged or lost, the purchaser will be liable for the purchase price. This will always apply unless the parties agree to exclude this. You are free and the shopkeeper is free. Oh, this is what I wanted to say. These requirements, please note, the price must be fixed. You must have agreed on the price. This is a general mistake. I'm pointing this out because this is a mistake that students make quite often, that they will say that the contract, in order for the contract to be perfected, the price must have been paid. That is, the price being paid is not a requirement for the contract to be perfecta. There must just be an agreement about the amount of the price. So let's just illustrate this quickly, just to summarize. I'm not sure who I was selling my cell phone to last. Let's say it's Stacy again. I enter into an agreement with Stacy that she will buy my cell phone and she will pay me and take delivery at the end of the month. Between now and the end of the month, I must keep the cell phone in safe custody. I must make sure that it's protected. I mustn't leave it lying outside in the rain or drop it or throw it around or whatever. If we agree today that Stacy will buy my cell phone for $1,000, if her father is prepared to give her the money, that contract is not yet perfecta. We have a price. We have the cell phone, $1,000. We have a thing, the cell phone. But there's this condition, a suspensive condition. If her father is prepared to give her the money, while we are waiting for her father to confirm or not, the contract is not yet perfecta and the risk has not passed to her. Now, next week, her father says, yes, Stacy, I will give you the money. Now the condition has become fulfilled. The contract is no longer conditional. The risk passes to Stacy. She's only collecting it at the end of the month. I must still keep it in safe custody. The risk rule applies only to accidental damage. Accidental damage. Damage that was not in my control. So if I leave the phone outside and it starts raining or I drop it in the bath or something, it was because I didn't keep it in safe custody. If, however, I have it in my house and despite my front door being locked and everybody, I have a robbery at night and people break in, armed robbery, and they steal the phone. So it was damaged or lost, not because I did something wrong, something beyond my control. Stacy, bad news is you're not getting a phone at the end of the month, but you must still pay me $1,000. That is how it works. I can agree that, okay, Stacy, let's cancel. You don't have to pay me. but I don't have to agree. If I want to, I can insist, and I can even take her to court and claim that $1,000 from her. Is everybody with me? Do you understand this? Think with your heads, not with your hearts. There have been some questions clarifying. Thank you for that. Is everybody with me now? I'm going to leave this with you. I'm going to stop here.
Ma'am, I
Because
have a question.
Okay, just give me a second. I just want to copy and paste here quickly. Before you ask, so that I can focus on what you're asking. Okay. Yes, Martha, go ahead.
Oh, you mentioned something like for the condition of a contract. If Stacy father said no, I'll give you the money. It's a confirmation. Is that
Yes.
is that all what we can rely on, or only if the father gave the money? Or can you go back to
Okay.
the slide?
Okay, Martha, you need to go back. You need to go back, because I'm not going to be teaching things that I've already taught. Suspensive conditions. I did in previous lectures, I did conditions. What are conditions? What are suspensive conditions? The agreement that if Stacy's father will give her the money is a suspensive condition. If her father says, no, I'm not going to give you the money, then the condition is not fulfilled and the whole contract will lapse. It will fall away. Because the continuation of this contract depends on her father giving her the money. So if her father says, no, Stacy, I'm not giving you the money, the contract falls away. There's no more contract. There's no passing of the risk rule. There's nothing. There's no contract. If her father says, yes, Stacy, I will give you the money, then the condition is fulfilled and the contract becomes complete. It becomes perfecta. And when it becomes perfecta, the risk passes to Stacy. If it is damaged accidentally after it became perfecta, then she is still liable to pay the full purchase price. Is that what you were wondering about?
No, that one I got it. I was just wondering if then the father maybe changed the mind, but then I believe now when you said it's suspicions conditions, it's when he agreed, not necessarily whether he's going to change his mind and so on, but to focus on the.
No, Martha, he cannot randomly change his mind. Once he has agreed, the contract becomes perfecta. If he subsequently changes your mind, that doesn't have an effect on the fact that he said yes, the contract became perfecta. So even if he then doesn't give the money to Stacy, she'll have to find the money somewhere else.
Okay.
We need finality about this contract at some stage. He can't say yes, no, yes, no, yes, no. So if he said yes the first time, the contract is perfecta and she's bound. If he changes his mind, it's between him and her. It doesn't affect my right to claim the money. Is that what you wanted to clarify?
Yes, ma'am.
Okay,
Yes,
wonderful. Thank you for your questions. Any further questions? I'm not going to continue. I'm going to stop the class here. There's one more duty. We still have the whole of next week. Let me just check our schedule quickly. Where are we now? Okay, yes, we still have next week to continue with Unit 9. So we are now comfortably on schedule. There's no need to rush. So yes, so there's no need to have a class then on Saturday because we are now on schedule. Eiley, your hand is up. Okay, now she disappeared. Any last questions before I end the class? Stop the recording. Okay, thank you very, very much.